Hello everyone and welcome to week 4 of Introduction to Law. And in this week we're going to start our examination of the specific sources of law, and we're going to start looking at rules as a source of law. Now, rules are most commonly embodied in legislation. The other major source we're going to look at are precedents, which are most commonly embodied in judgments. There is some overlap between those, so it's not as simple as that. But if, as a starting point, it's worth thinking about rules as being general statements of principle that look forward. So the Dog Act comes out and says it's illegal to own, from this point on, it's illegal to own an unlicensed dog with this penalty. It's expressed in very general terms, and it looks forward in time from this point onwards. Judgments, on the other hand, are backward-looking. They look at a set of circumstances that actually happened, and they look at applying the principles back to them. So someone's out with their unlicensed platypus, they get charged under the Dog Act. Is a platypus a dog for the purposes of the Dog Act? So we then look at the precedents to go back to a specific situation and to apply the law in that circumstance. So much of legal interpretation is this dance back and forth between those general principles and those specific precedents and how they work together. And that balance is very much a symptom of our system, common law system, and it's quite different if you go to other traditions. Our system has a very large role of discretion in the application of rules. And as a result, it's fiendishly complicated and it's very difficult to be a lawyer. If you compare to the situation in China, for example, they focus much more on rules rather than discretion. Precedent has a very little part to play, and the rules are applied pretty strictly. And judges aren't terribly highly paid senior servants because they don't do a lot of judging. They just take the rules, apply them to the facts and the way they go. And a lot of different systems work like that. They really much focus on law being very rules focused, not so much the discretion. And you get this interesting conversation where you get a stereotyped Western lawyer going to China and saying, how unfair is your system? There's no wiggle room here. It's just absolute black and white. There's no way that you can modify those results to make them more just and more fair. But you go back the other way and the Chinese lawyer looks at our system and says, how is your system just at all? You can never predict what discretion is going to be exercised. You've got no idea where you stand until something actually goes to court. Our system is far more just because it's certain, because everyone knows where they stand. So both arguments are valid, and they're both really about the different cultural approaches to the law and the way it's used. So, as I said, this week we're focusing on the rules side of things, and that's those general principles looking forward, and then it gets muddier next week when we start bringing in the precedents that say, oh, well, but maybe in this circuit, maybe we'll change things around. But it gives us a lot more flexibility to come up with a solution, a result that we think is a fairer and juster one. Our approach to rules are also expressed through principles that may not be in legislation, but are in our philosophy and a way in which we approach law, and we'll talk about some of those in a moment. So things like rule of law and equality before the law and the principles we have also form part of that backbone of the rule system that we interpret the other rules in the light of. We must have meant it in this way because we always tend to approach issues in this particular way, and if there's an ambiguity in interpretation, we'll decide that we must have been intending that the meaning that is consistent with our existing set of legal principles, our legal ideas apply. All right. So one of the other things that I talk a lot about, this distinction between rules and precedents, and the fact that they don't necessarily map up to cases and legislation, because legislation can have precedents in it. It can have examples. It can say, for the purposes of the Dog Act, a dog includes this, and this. A dog does not include a platypus. They could do that discretionary stuff and fill in some of that effectively common law in an act. an Act of Parliament that would ordinarily look like a set of rules. And in the same way, where there's gaps in the law, the common law judges can set up rules. They can say, we're deciding that this is the rule in this particular case. So while we're going to cover those sources of laws separately in each week, remember that they do overlap somewhat in their operation. One of the important things when we're studying law at the beginning is to try and denaturalize our understanding of the law. And what I mean by that is we're so used to our own way of approaching things that it seems like the only way to do it. And one of the things to start doing is to start looking at it as a weird and strange exotic system and start to understand that this isn't the way things have to be. It is quite possible. Many people around the world work in a system that there's no precedent. They don't work in a common law country, where there's different forms of discretion exercises by judges and officials. So we have to, weigh up those different things, but also look at our system with fresh eyes and be able to see it as an artifact, as a product of a certain culture in a certain time and place. Okay, so what else do we look at this week? We look a little bit about the origin of law, the origin of colonial law in Australia, the status of Indigenous law, and a bit of a comparison there to, say, the Treaty of Waitangi in New Zealand, which was a very, very different approach. Same part of the world, but a very different approach to the status of Indigenous law. Then we look at some of the principles, the theories, the ideas that underlie law, and I think these are really important, not as an abstract theory to know for the sake of theory, but to actually understand why our law is designed in the way it does. And the rule of law is a big one. It's kind of like the big transcendental myth of law, that the law gets its validity because of rule of law. It just talks us around in a circle. But there is this idea that fundamentally law is its own creature and it is separate from the discretion of the powerful. So just because Rupert Murdoch wants something to happen, he can't just snap his fingers and make it happen. He has to, like everyone else, approach the law. No matter how wealthy he is or how many corporations he controls or how much of the media he controls, our foundation idea of the law is a homeless person and Rupert Murdoch have the same access before the law. And that was very important in the formation of our law in a period where we moved from monarchy, where kings had absolute power, to parliamentary sovereignty and the separation of that idea of power being from the hands of the powerful. The law stood as a barrier, a separation to create equality before the law. Now, of course, that does not work in practice. Not all the time, not often. But as a core theory and idea of law, it's one that's worth hanging on to. Because if you abandon that, if you say, well, the system just favours the powerful anyway, you end up with no position. You've argued yourself out of firm land. You've argued yourself into a position where you just say, well, the rich and powerful may as well just do what they want. If we believe the whole system's corrupt, so it's a tough position to take as a lawyer and a legal professional, to stand by rule of law, because you will constantly be told, well, what about this, but what about this, what about this, and what about this? But it is important that we do hold on to that and strive to make the system better, that we can protect this idea of law being impartial above everyone else, and not subject to power. We know it is, but we've got to work to make it better. Other important ideas that we talk about this week is there's a video I've done on liberalism and democracy, and unpacking some of the historical ideas that underpin our idea of law, particularly our idea of law as a collection of rights. It's very important to our system, but it's very specific to our system, and it's alien to other ways of thinking. And one of the things about rights is it comes out of an area where personal property was being redefined. So we tend to think of rights as a form of property that creates all kinds of strange situations down the track. But we do need to know a little bit about that period and those political ideas that the law came out of, and to know that liberalism is not just when the talk show hosts rant about the Liberals do this and the Liberals do that, or the Liberal Party in Australia. Those are not really what we're talking about. We're talking about liberalism. We're talking about the Enlightenment philosophy, that sort of humanist philosophy, but was also the philosophy of the landowners and the capitalists. Okay. What else do I want to talk about? Big one's parliamentary sovereignty. It's in the notes, but it's very important, and it's the principle under which legislation trumps judge-made law, common law. So it's a very important one. When you get tied up in those knots of what principle applies, always go with the Parliament said. But as I mentioned at the outset, that difference between the general nature of rules made by Parliament and the specific discretionary nature of precedents that are made by judges means that quite what often happens is Parliament will say this is it and this is a clear statement of the rule, and then the courts might go, oh yeah, but we interpret it this way, and they do a little bit of legal fidgy-widginess around what it is, and then Parliament comes back and says, no, we're amending the law, we don't want it to be ambiguous anymore, we're going to say this, and then the courts may come back and go, oh, but it's not really clear in this area, and so you get this interesting conversation between those things, where just because what Parliament says goes doesn't mean it always goes, and the fact that the courts are in the coalface when decisions are being made can often mean that they have a lot of power to work around those words, or often it's just the words are not really well defined, or the situations that appear before the courts are not anticipated by the rules. That happens as well. That something comes up and people go, oh, we didn't really think about that when we created the rules. And that's where you need that discretion to be able to say, okay, no one ever thought that the dog catcher would catch a platypus and try and, find someone for the platypus. It was just unthinkable at the time. We didn't think we needed to specify in the Dog Act that dogs didn't include platypuses. And that's where there's actually a very useful role of the judges, who can say, well, okay, we're going to look at our principles, we're going to look at our rules for deciding what rules are, and we're going to say that, of course, it doesn't include a platypus, it's not a dog. Or they'll be really legally pedantic and they'll say, oh, well, the rules say a dog is a four-legged animal and a platypus must therefore also be, or whatever the decision is. I mean, that was a completely arbitrary example, but that's the kind of interplay you get, and that's, I think, something to keep really clear in your mind when you say, well, why are we reading legislation and why are we reading cases? It's two different approaches that meet in the middle somewhere. We do a little bit on statutory interpretation this week, which are basically the rules of grammar as legally recognised when you're looking at rules. Now, if you are a law student and you're full-time, you will probably also be studying a whole subject on statutory interpretation. And you may be saying, why are we looking at statutory interpretation here? We're looking at it somewhere else. Well, about half of the students are criminology students, so they don't do that unit, and a lot of law students are part-time, and they may not be picking up that unit until later on in any case. So it's important we just have a brief overview of those different rules, and you understand how they apply. And they're really just sort of, explaining how grammar applies in the legal context. All right, I think that's all I wanted to say about the material. You can read all the details in your own time. The challenge this week is bring along, and make sure you do this ahead of time, bring along an activity that you... bring along a set of rules. And there's a whole lot of different rules you can apply, and it can be something as, complex as the handbook of the rules of cricket, or it can be something as simple as the rules that are written on a plastic bag that you get that tells you, this bag is not a toy, don't give it to children, whatever else. And what we're really talking about and thinking about in our groups is the way in which these broad principles, like quality before the law, rule of law, and different legal ideas, then get expressed in sets of rules. Because you can really see, particularly in rules of games and rules for children, a way in which these rules have an educative function, and they socialise people into working in a society that has a set of rules and working within the law. So you can see the resonance of those things, or you can see jarring examples where it's like, well, that's different We've got a situation where the decision in a game or a sport is made arbitrarily by someone, and it wouldn't cut it in democratic society where we'd want people to have input or whatever. So have a look at the challenge. We'll talk about that in class, of course. The important thing is that you make sure that you've prepared ahead of time and you've got something to bring along and talk about in those small groups. But yes, it's as we go through the discussion, you'll no doubt be not surprised, but you'll be able to see how some of these things that might seem really theoretical, about rule of law and what is all that about, and we look at how an umpire in a sports match works, and we realise, okay, they embody a kind of rule of law in that circumstance. That's very important. And before we go, I also wanted to have a quick update on the check-in surveys for this week. Thank you for continuing to give me your feedback on this, and it's important we close the loop each week so that I get back to you about my responses, so we know we're all on the same page. The first couple of questions were about your confidence going into the course and your confidence as they stand now. And it's exactly what we wanted to see. Most people were feeling fairly anxious and not so confident at the start, and are feeling better about it now. So that's very gratifying to see that there's been an improvement there, and people are feeling better even at this early stage in the course about how to think like a lawyer. In terms of what we learnt this week, there was a bit of a split between critical thinking and case analysis. Might be the split between the criminology students who are more aligned towards critical thinking, and the law students who are more focused on the cases. I mean, I don't know. That might be how it splits, but there certainly seemed to be a split there. Definitely, those are important things that we pulled out of learning for this week. People also mentioned, some people mentioned the logical fallacies, and there's a whole world of study in terms of logic and presentation and arguments. So this sort of just to start off. The next question was about speed of the course, and 63% of you thought it was about the right speed. So that's really good to hear. There were a chunk of people who thought it was going a bit fast. 30% of people thought we were going a bit fast. That's it is inevitable because we're trying to cram in so much in this one unit, and it's so front-ended. But small number of people thought we were going a bit slow. That was only one person. There we go. One person thought we were going a bit slow for them. So that's again a useful little bit of information for us, and all this information is useful because it's how we know what we're doing. Okay, and the last was the what would you like to have explained more? Overwhelmingly, it was about case notes. That's okay. We talk about cases next week, and we're going to talk about case notes a little bit more there. And again, there's no magic solution to case notes. We'll look at IRAC as the safety wheels, training wheels. I'll get to the right word eventually. Training wheels to get you started in your analysis, but there is so much more. And if you are a law student, you're going to spend your academic career and further really developing those skills. It's not something like you can go, okay, I've got the method down, that's how I write a case note. And your ability to write case notes deepens as your knowledge of the law deepens as well. Just quickly scan through the comments to see if there was anything else people wanted more information on. Case notes. Some more on fallacies. We're not going to really touch that much more on logical thinking as we go. There is some good, I'll have to try and see if I can find them, online resources on things like logic that are quite useful to help you understand the process. But yeah, wasn't anything particularly else that stood out there as well. So we're on track, and the thing that most people seem to be struggling with is something that we are going to come back to and talk about next week, I believe. So okay, I will see you all in class.